Hello viewers, Namaskar. I am Dr. Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on the 3 new criminal laws. Today is the 3rd lesson as a part of that series. In the earlier 2 lessons, we tried to decode the title, like the laws have changed from Indian Penal Code to Bharatiya Nyaya Sanhita. Criminal Procedure Code has changed to Bharatiya Nagarik Suraksha Sanhita, and the Indian Evidence Act has changed to Bharatiya Sakshya Adhiniyam. Also, in lesson 2, we tried to understand the objective behind the restructuring, how the sections they have been rearranged, some new sections have been added, some redundant provisions they have been deleted. So, what is the new frame of chapterization of those new laws? Today, we will talk about the conceptual changes in the 3 new criminal laws. So, foremost, there has been a paradigm shift. The 3 laws, they embody a very progressive approach. So, now, instead of focusing only on punishment, focus is also on providing justice, and justice not only to the victims, but to all the stakeholders in the criminal justice system. And that is what is evident in the title itself. Earlier we were talking only about penalty in Indian Penal Code, but now we are talking about Bharatiya Nyaya Sanhita. So, you see, the focus has shifted from punishment towards justice. Then in Criminal Procedure Code, when we shifted the title from CRPC, we changed the title from Criminal Procedure Code, which was focusing only on laying down what is the procedure to be followed. Now the law is Bharatiya Nagarik Suraksha Sanhita. So, we are talking about protection. So, the law is now from punishment based to protection based, and protection to all our people. We have also introduced the concept of restorative justice. So, it is not merely about punishing the offender, it is not only about having a deterrent effect. Now we are talking about restoration. So, restorative justice is like in which form we have introduced it in the form of community service, whereby we are not putting the offender behind the bars. So, it is a non-custodial kind of punishment in which we are allowing the offender to atone for the wrong which was committed by that person. So, that is something which would be given only in cases of petty offences to first time offenders, those people who have the capacity to be brought back in the mainstream of the society. So, although we need to retain the deterrent element, and that is why we have retained the death penalty. But again, we have qualified it by the rarest of rare doctrine. So, while retaining the deterrent element in our laws by prescribing harsher punishments to some offences, we have also introduced the concept of restorative justice. And now, there is a better structuring of the laws. So, it makes it easier for people to comprehend what the law is. See, law is meant for the people, and what is important is that it should be in an easy language so that anyone who reads the law can make head and tail of what the lawmakers wanted to say. If the language is too technical, if it is complicated, if it is not structured properly, like if you have to look for, if we talk about offences against women. So, what is the protection that has been given to women under the law? One offence it is given in chapter 4, one offence is given in chapter 9. So, how do you connect all of them? So, what is required is that when we were changing the old law which was enacted in 1860, so now we had an opportunity to structure it in a better manner so that anyone who wants to know what the law is, they would be able to understand it in a very easy manner. Okay. In addition to that, all definitions now, they have been updated we need to update the law. Law exists for the people, for the society. So what is important is that law has to be enacted keeping in mind the changing needs of the society. So what was required was updating the definitions which were put in the law when the laws were enacted by the Britishers way back. Okay. So now definitions, they have been updated and they have been included in one place. Moreover, now what has been done? We have arranged them alphabetically. What happens, like when you look for a term in the dictionary, it is very easy to search for that term. Why? Because of the alphabetical arrangement. Similarly, when we are trying to decipher the meaning of any term in a criminal law, if they are to be structured and placed in an alphabetical manner, it would be very easy for anyone who wants to understand what that term means. It would be easier for us to locate that definition and further to read it and analyze it. Then some acts, they have been criminalized, like see, homosexuality, it was a crime, adultery, it was a crime, but then we got certain landmark judgments in which the Supreme Court of India struck down those provisions as being against the Constitution of India. See, IPC was drafted in 1860 and our constitution we got only when we got our independence. So now any law, in order to be a valid law, has to be approved on the touchstone of our constitution. So what is important is that if there is any law which violates the basic tenets of our constitution, then such laws, they need to be struck down, and that is why those laws, they were struck down by the courts, by the honorable judiciary of our country. And now when we were redrafting the laws, so we effaced those provisions from our statute books. So while we have provided enhanced punishments for some offences they have been removed, redundant provisions, they have been deleted. Significant judgments of past few years have been included, because see, lawmaking is essentially a legislative function and lawmaking requires a lot of time. So sometimes what happens, when we need to bring about a change, at that time the judiciary steps in. It either strikes down irrelevant laws, or sometimes they exercise their powers under Article 141 of the Constitution of the India and they supplement the gaps. Sometimes we need certain provisions, like although we had our constitution in place, we had reenacted the procedural law in 1973, we tried to constitutionalize it, but then we realized that we did not have adequate provisions to protect the rights of arrested persons. And that is something which we have to do, keeping in mind our constitutional provisions as well as the international instruments of which we are signatories. So what the Supreme Court did, it provided us certain guidelines to protect the rights of arrested persons. So that is how the courts have been working. And now what was, we had an opportunity, since we were enacting new laws, what we did, we introduced all those relevant provisions, whether it was in that particular judgment, whether that was in other landmark judicial pronouncements, we enacted all those decisions in the form of statutory provisions in the new laws. Then we are also talking about gender neutrality, because now is the time when we have acknowledged transgenders also to be human beings. Now is the time when we have realized that see, men and women, they are equal. So now is the time to bring in gender neutrality in our legal provisions as well. Then again, laws, IPC 1860 it was enacted, Evidence Act 1872, and the society, it has been developing it at a very, very fast pace. So much of technological advancement, so much of technology that is being used in day-to-day lives. There has been a cyber revolution. So we have to be very mindful of the fact that laws, they have to incorporate. We need to utilize technology. We need to utilize forensic sciences in crime investigations. And that is absolutely must, because otherwise we would not be able to appreciate the evidence in a very proper manner. Similarly, registration of FIRs. Earlier you would have to travel to the police station and then only you could register an FIR. But now you can do that online also. So like EFIRs can also be registered, and that is very much keeping in mind the changing needs of the society. Thereafter, what was required was to fast track of cases. See, we all know that justice hurried is justice buried, but justice delayed is justice denied. If a person has to keep waiting for years altogether, even in the most smallest of cases, people's confidence in the judicial system, it erodes over a period of time. So what was required was that we needed to bring in fixed timelines. Whether we are talking about investigations that are being conducted by our police forces, see, we need to inspire confidence in our people. That is why, and moreover, the police also they need to act very promptly. So when we have ensured that investigations they are conducted in a time bound manner, people they have a feeling of confidence. We feel more secure. Then talking about trials, see, again we cannot allow unlimited or n number of adjournments in any single case. So the trials they also have to be conducted in a time bound manner. If the accused is not being apprehended, if the accused flees the jurisdiction, sometimes flees the country, due to which we cannot get the accused person before the courts. Earlier what would happen? We would say that, see, as per the principles of natural justice, no one can be condemned unheard, and we would keep waiting for unlimited time for the person to make a personal appearance before the court, so that he could be cross-examined or so that the case could proceed. But now we have to take cognizance of the fact that sometimes people they take advantage of such lacunas and loopholes in the criminal justice system, and they deliberately they try to evade justice. So now what we can do is, we can examine the accused through video conferencing, where he is not available through video conferencing also. So what we can do is, we can hold in absentia trials also. Similarly, now once the trial has been conducted in a fixed time bound manner and the judgment has been reserved, so there is a specified timeline for pronouncement of judgment also. It is not that the people, the litigants, they are like waiting for a long time for the judge to get the time to write a judgment, thereafter to pronounce it. So what is required now? The judges, they also need to get their act together. They need to work. See, although we cannot close our eyes to the fact that our judiciary is overburdened, but that is another thing. Maybe we need to appoint more judges, we need to up our infrastructure, but all said and done, the people they are not supposed to suffer. So judgments they are also to be pronounced as per the specified timelines. Then again, another very important point that has been introduced here is that when we talk about petty offences, for petty offences, if you do something which the law forbids you to do, so that is a crime. You would be tried for that, but sometimes the damage that you have done to the society is quite less as compared to the damage that is being done while trying you. So much of money is being spent on conducting those trials. So in such cases, those kinds of offences, they can be tried in a summary manner, and summary trials, they have been made mandatory. So we can leverage technology. We have to utilize technology to make conducting of trials easier, whether we are examining the accused persons or the witnesses through video conferencing. Wherever required, we have to adopt technology in order to cut down the time. Now, in the new law, victim has more say. Otherwise, what would happen in the criminal justice system? It was all oriented towards the accused person, because the title of the law was punishment based. So when we were focused on punishing the accused, we paid no attention whatsoever to the plight of the victim. So once we knew that a crime had been committed, our entire focus would be on investigating and collecting evidence against the accused persons. And sometimes what would happen, the victim was totally out of the criminal justice system. Sometimes they would be in the system as a part of the witness, but more often than not, victims would have no say. In the new law, victim has more say. Victims, they have to be supplied copies of FIRs. They have to be kept updated about the progress of investigation step by step. In cases where punishment is 7 years or more, so where it is a serious crime that has been committed by the offender, even in cases where the state decides to withdraw the prosecution. See, this is a monopoly of the state. If the state decides that we do not want to prosecute this offender because crime is a public wrong, and prosecution is always initiated by the state. So if the state decides to withdraw prosecution, earlier the victim had no say. But now, when we are talking about an offence in which the victim was so severely harmed that the punishment that has been prescribed for the crime is 7 years or more. So we can imagine the kind of peril that the victim was put to. So in such cases, what does the law say? Now, victim has to be heard, and the state cannot decide withdrawal of the prosecution in a unilateral manner. The victim has to be given an opportunity of being heard before the court takes a decision in this regard. Then, witness protection scheme. See, witnesses, they are the eyes and ears of the criminal justice system. Unless and until we have witnesses, our investigations, they will not be able to be conducted in a foolproof manner. So now we have a witness protection scheme which has been introduced in the statute. There is one single provision which has given this discretion to the states that as you require, you have to enact a witness protection scheme. The protection scheme has to be mandatorily drafted, but they can have some differences depending upon particular states, the needs of any particular state. They could have some different provisions, but by and large, now this is a mandate for all the states to now enact a witness protection scheme in their states. Now, let us talk about the main conceptual changes in the sense that how have the definitions been overhauled now? How has the interpretation changed? The terms are more or less the same, but it is the way that we understand those terms, the way we interpret those terms, and the way we apply those terms that can make a lot of difference. So what has been done now? Many definitions, they have been changed to suit the changing needs of time. So now, first of all, we will talk about the definition of the term child. See, earlier the term child was not defined in the Indian Penal Code, and the term that we were using in the IPC was the term minor. And then there was different age of majority for different offences. Like if we talk about age of consent, earlier it was 16, it was raised to 18. So a girl was considered as minor till the time she attained 18 years of age for the purposes of rape. But when we talked about kidnapping, she was a minor even if she was 17 years of age, because the age was like, if she is above that is, she should have been below 18 years of age. For kidnapping, yes, if she was below 18 years of age, and age of consent was 16 years. So that is how the law was. But now what we have done, we have introduced one uniform age, and that uniform age is 18 years. So you see, for child, why we needed to bring in this uniformity was because we got the POCSO law in the year 2012. POCSO is Protection of Children Against Sexual Offences Act. So we got POCSO in 2012, and now irrespective of the gender of the child, any person below the age of 18 years is considered to be a child. We replicated the definition now in Bharatiya Nyaya Sanhita. Why this was more required was because, see, in the year 2019, we got the Transgender Persons Right to Identity Act. This we got in the year 2019. Now we have acknowledged transgenders also as persons. They have a right to identity, they have the freedom of expression. So now A child could be a boy, a girl, it could be a trans person, it could be any person below the age of 18 years. Now, why this was very, very important was because, see, ordinarily, this is the growing age, especially the pre-teens and teens, when the child starts to understand or appreciate his or her sexuality, and sometimes when the child does not fit in the established binary. Okay. So what happens? People, they start mocking that person. Family members are also not so accepting of someone who does not fall in the two neat compartments that we have drawn of male and female. So parents, they also start rather abusing the child. There have been instances where children, they have been subjected to some sorts of hormonal treatments, sometimes corrective rapes at the hands of their own family members. So what happens when the child is not accepted in those growing years? Children, they become recluse, they start isolating themselves from the society, and such children, they are easily victimized by predators. Many times children, they run away from their homes, and then they are like picked up by some gangs who employ or engage them in prostitution or in begging and different kinds of trafficking. So they are highly susceptible to all these kinds of offences. Moreover, earlier the law was meant mainly for protecting girl children. But after POCSO, when we understood that the law is expected to protect all dependencies, vulnerabilities, so children, whether it is a male child, whether it is a female child, whether it is a trans child, now all children, all people below the age of 18 years, they have been put together in one category, and there is one single definition for them, and that would be the term child, irrespective of the sex of the person, irrespective of the orientation of the person. So that is a very, very progressive definition now, in which section 2 clause 3 of the BNS defines child to mean any person below the age of 18 years. Then moving to section 2 clause 8 of BNS, which defines the term document. So document now, it means any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of these means, and includes electronic and digital record. So now this is a new phrase that has been introduced. We already had the definition of the term document in IPC, but now what we have done, we have inserted these terms that document would also include electronic and digital record. So again, I'll read the definition. What does it say? Document means any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of these means, and includes electronic and digital record intended to be used or which may be used as evidence of that matter. So now this is a progressive definition. In the electronic age, when everything has been digitalized, we have most of the data in electronic form, how can we close our eyes to the fact that most of the documents nowadays, they are being prepared in the electronic manner? So that is why this is a very, very progressive and an inclusive definition. Then coming to another progressive definition, which is section 2 clause 10, gender. So now it says the pronoun he and its derivatives are used of any person, whether male, female or transgender. So when we are talking about he, his, him, so the single pronoun he, all the derivatives of that pronoun. So when we would be talking about he, his, him, so it would be an inclusive definition. We would not say that it says he, so this is a law which is referring to only male, or which is referring to only men, because now we have a definition which says the pronoun he and its derivatives are used of any person, whether it is male, female or transgender. Earlier the definition said any person, whether male or female. Now we have introduced the term transgender also. Why? Because it was much needed after 2019 Act. The explanation that has been appended to section 2 clause 10, it further clarifies. It says transgender shall have the meaning assigned to it in clause K of section 2 of the Transgender Persons Protection of Rights Act 2019. So now when we are talking about human beings, when we are talking about persons, see, we are not going to judge any person on the basis of their gender, on the basis of their sexual orientation. No one is a child of a lesser God. We are all equal. And now the pronoun he and its derivatives, that would include all persons, whether we are talking about men, women, trans people, and everyone. So students, this was all about this session. In the coming session, in lesson 4, we will continue with the conceptual changes that have been brought about in these 3 new criminal laws. Thank you.